And now, the student loan giveaway. Ever since President Biden announced that he was going to forgive outstanding student loans under a certain income level, all sorts of people in both parties have declared it unfair. Unfair to the people who paid their way through without a loan, and unfair to people who went straight to work without college, joining America's workforce. Well, what he's trying to do might not even be legal. But that hasn't stopped the Biden administration from launching the website and taking down information on millions who want to see their loan disappear. Mark Chenoweth is here from the new Civil Liberties Alliance, which filed suit on the matter. Mark, good to have you here. Thanks for joining us.
Good to be with you again, Doug.
Now, you are not the first to file suit against this Biden administration policy of student loan forgiveness. But when it was done earlier in this month, U.S. District Judge rejected the lawsuit. U.S. District Judge Henry Autry in St. Louis ruled that since the states of Nebraska, Missouri, Arkansas, Iowa, Kansas, and South Carolina failed to establish, quote unquote, standing, the court lacks jurisdiction to hear the case. So standing, or the ability of whether or not you're directly affected by the lawsuit, is absolutely key here. Tell me how your lawsuit differs from the lawsuit filed by these states, which a judge has said lacks standing.
You're absolutely right. Standing is key to all of these cases. There was an earlier case dismissed on standing grounds in the Southern District of Indiana as well. And so this is going to be a major issue in these cases. The reason why I believe our case has standing, that the New Civil Liberties Alliance has filed on behalf of the Cato Institute, is that there was a pre-existing student loan forgiveness program passed by Congress and signed by the President in 2007. This public service loan forgiveness program had certain criteria in it that Congress had established that said that if you went to work for 10 years for a 501c3 organization, for example, a public interest type of nonprofit organization, and that you made all of your loan payments for that 10-year period, so 120 monthly loan payments, then the remainder of your student loans could be forgiven at that point. What the Biden administration has done with the loan program that it has tried to put into place without any congressional authorization would wipe out that program, or would really undermine the way that program creates an incentive. And so that's why we think there's a harm there, to not just to the Cato Institute, but to all 501c3 organizations. And that harm creates standing for them to sue.
So those people who had their loans forgiven through the 2007 policy are the victims here. That's what you're saying.
Well, really, it's the employers who have relied on having access to a workforce. So when you're speaking as someone who runs a nonprofit organization, I can tell you we can't afford to pay the kind of salaries that the private sector can pay. But one of the things that Congress has provided is this ability for folks who take those lower paying jobs to have their student loans forgiven. But if they can have their student loans forgiven regardless of whether they work for a public interest organization, then that incentive is taken away. And the president doesn't have the right to take away an incentive that was created by Congress like that.
And what's the status of your lawsuit? Has it been filed yet? Has it been heard yet?
It has been filed in the District of Kansas. It has not yet been heard, and we have filed both a complaint, and we've now filed a motion for a temporary restraining order, a motion for preliminary injunction. The government has not responded to the complaint or those motions, and the court has not yet ruled on them. But we do expect action here within the next week or so.
It seems to me that we're following through on this legal pathway simply because, again, Congress has failed to do its job. They are, the House of Representatives in particular, is responsible for doling out federal money, and they're not doing their job.
Well, and that's, you're right that it is Congress's job to do this. And here, the administration has tried to act without Congress, and that violates the Appropriations Clause. Article 1 of the Constitution gives the power of the purse to Congress, and Congress is the one that would have to pass a program like this. In fact, they did pass a program like this, the one I mentioned that they passed in 2007. But it had very specific criteria, and it didn't apply, it didn't forgive everyone's debt. It only applied to a small segment of the workforce. And for the administration to go beyond that, to pass a $500 billion or to try to promulgate a $500 billion program without involving Congress, well, that violates Article 1, Section 1, which is the part of the Constitution that vests legislative power in Congress, not in the president, not in the Department of Education, but in Congress.
Do you maintain, as others have, that the President of the United States knew that this was unconstitutional when he took this executive action?
I don't know how they couldn't know that, Doug. I mean, this is breathtakingly unconstitutional. It's not even a close call. The administration has tried to pretend that there was a statute called the HEROES Act passed back in around 2003 that gave the Department of Education the ability to delay some loan payments and that kind of thing for soldiers who might be stationed overseas and might miss loan payments as a result of that. They're trying to take that very small program that was passed. I think there was only one vote against it in the House of Representatives. They're trying to take that and pretend that it was a vote that would allow the department to do this $500 billion program. But it clearly didn't do that. It wasn't that vast an amount of authority that was granted. And if it had granted that amount of authority, there's a question whether it could be constitutional even on that ground.
And Mark,
the Supreme Court.
Now, let me add, we have limited time, so last question for you. What is, in your opinion, the moral hazard, if any, regarding this policy, in the sense that the administration has selectively chosen people who took out loans to go to college as worthy of forgiveness? There are a lot of people who take out loans for a lot of reasons, not necessarily to go to college. They're left out of this. What do you make of that?
Well, two things on that, Doug. First of all, that's a policy decision for Congress to make. It's not a policy decision for the executive branch to make. That's part of the problem here. And I do think it creates a moral hazard. I think that the administration has called it a one-time loan forgiveness program, but that's not going to be the effect here. We've already seen colleges raise tuition in response to this announcement from the Biden administration. And if they think that students are going to be able to have loans forgiven, that increases their propensity to raise tuition rates. It increases the amount of money that students are going to be willing to borrow in the future because they think that there may be a chance that it gets forgiven. It has all sorts of pernicious effects, as you allude to, and I'm very concerned from a policy matter, but mostly I'm concerned that this is just plain unlawful and violates the Constitution.
Mark Chenoweth of the New Civil Liberties Alliance, please stay in touch with us and let us know of any new developments as this suit makes its way through the courts. Thank you, Mark.
Be happy to. Thanks again.